Today's lecture focuses on the question of rights and access in the digital realm. Let us begin by asking why this question is so important to citizens of the digital world, or netizens as we sometimes call them. The digital revolution has brought enormous resources, whether in the form of text or as images or as sound, within easy reach of countless people across the world. As you all know, it is possible today to download and read an entire book, or to watch a film, or to listen to music online. And as we perform these actions, as we access and consume digital material, we do not always ask who owns the copyright, more formally, the intellectual property right to this material. But this is, in fact, an important question, and to understand it, we need to look briefly at the notion of intellectual property rights. The invention of writing brought in, we might say, the first knowledge revolution. Writing enabled the transfer of ideas and forms through the medium of written text to large numbers of people who might be unknown to the writer. While the speaker addresses an audience that is physically present before her, a writer can communicate with distant or absent persons. But this also means that the writer has to leave a mark on the text to be identified as its author, since she or he cannot be physically present when the text is being read. Thus, a text might carry a name below its title, or the author's name might be worked into the text itself. Take an example from a very celebrated and much read book, Mahabharater Kotha Amrito Saman, Kashiram Das Kahe, Shune Punnoban. The stories of the Mahabharata are equal to nectar. Kashiram Das narrates them, the blessed hearken. The name of the author here is Kashiram Das. The second knowledge revolution came with the invention of printing. While handwritten texts or manuscripts could be copied and circulated, printed texts extended the range of circulation by many thousands. The printing press, using movable type, enabled the production of hundreds of identical or nearly identical books, which entered the print market as a popular commodity. Since books were sold for money, the identification of the author as well as the printer or the publisher became all the more important. In the Western world, the notion of copyright is very much a product of the print market and print culture. It is linked not only to the profit motive, but also to official measures to regulate and control the world of print. Even before copyright acquired the legal character that it has today, we see Shakespeare's plays, for example, being listed in the stationer's register under the name of the printer or the publisher, with the author's name sometimes mentioned, sometimes not. In 1602, the printer James Roberts entered Shakespeare's play Hamlet in the stationer's register for his copy, without mentioning the name of the author. This may have been in order to assert a claim over the text and to block any other printer from publishing it. In 1604, the same printer, James Roberts, actually printed the play for the publisher Nicholas Ling. Thus, the idea of copyright emerges over a period of time, and its more formal beginnings are to be seen in the course of the next 100 years, that is, through the 17th and early 18th centuries. It was a measure taken in order to prevent unlicensed printing and piracy. It is defined today as a legal right over a work granted to its creator under a country's law. That is, copyright recognizes one's creation as one's intellectual property. It is usually limited for a period of time and can be shared or assigned by the owner to, for example, commercial publishers or producers. In India, copyright for books lasts for a period of 60 years after the death of the author. Other forms of mechanical reproduction, such as sound recording, that were invented in succeeding centuries, of paintings, photographs, and music, for example, also gave rise to copyright issues, and today there are legal provisions for artists' rights. Essentially, copyright law enables the creator of a work, and by extension its producer or publisher, to benefit from its commercial circulation and sales. Thus, the author receives royalty for each copy of a book that is sold and is protected by law from unauthorized pirating of the work. Let us note that in principle, the copyright provisions for the protection of intellectual property remain the same in the digital world. There may have been some amendments or changes in the laws of a specific country, and individual legal judgments may provide for special cases, while there are also legally valid agreements which allow fair use, such as the quotation of copyright material in, for example, an academic article. But basically, the protection of copyright and of intellectual property in general remains a major concern worldwide. In keeping with capitalism's obsessive interest in individual property rights, to goods, to land, to money, to what is mine as opposed to what is yours. These rights are protected under the laws of individual countries, such as the Indian Copyright Act of 1957, amended several times since then, notably in 1994, to extend protection from 50 years after the author's death to 60 years. Our focus now is on the third knowledge revolution, that is, the digital revolution. Even if copyright law remains the same, the advent of digitality has made copying easier, has enormously enlarged the range and circulation of copies, and has allowed them to be transmitted through a single media device instead of being locked into specific analog forms. Above all, it has created what we like to think of as a digital community or communities transcending national boundaries through the World Wide Web. Basically, the digital condition enables the transfer of enormous quantities of material, not just text, but also visual and oral content in a single medium to vast numbers of people. In one way or another, we are all inhabitants of this digital realm, and we freely download and listen to music, watch videos, and read books online. A great deal of this material appears to be free, in that we are not paying to consume it, apart from the cost of the data, while one would normally have to buy a physical book or a record or the reproduction of a painting. But, and this is the question, is the material that we access really free? What happens to the rights of authors and artists in the digital realm? How is their intellectual property protected, and how can their livelihood be assured? How do we define the issues of piracy, copyright violations, and illegal copying? We also know that while a lot of digital material seems to be freely accessible, there is a great deal that is not. New books and films have to be bought, many archives require subscriptions, and most journals charge high fees for access. What we will try to do today is to explore some of the issues of rights and access that are raised by the digital condition. In particular, we will look at an idea which, though not originating in the digital realm, has become very important to it: the idea of shared intellectual or artistic content, or, as some call it, the digital commons. Let us listen to a short talk on this subject.